Religious broadcasters. I've worked with all four of the organizations that are represented on the stage here in one form or another, and been friends with their leaders and these people for many years. And great group of people. All four organizations that are represented are members of NRB. And so we'll go down, starting on my far left, your far right, which is the correct direction. We have Ryan Baker, who's the Senior Vice President for Strategic Initiatives and Special Counsel to the President at Alliance Defending Freedom. Then next we have Jeremy Diss, who's the Senior Counsel at First Liberty Institute. Then Matt Staver, who's the founder and chairman of the Liberty Council. And to my immediate left is Brad Davis, President and founder of Pacific Justice Institute. I'd like you to welcome all of them. We have a few questions that we're going to ask, and I'm going to ask them in general, and then I want each of our four panelists to comment on each of the three questions that we have planned for this morning. So, Brad, I think I'll start with you. Can you tell us what you think is the current state of play at the Supreme Court of the United States, particularly on the free exercise of religion and freedom of speech? In each of the panelists, and focus specifically on cases that are pending and are likely to come up in the next few months.
Oh, certainly. One that I think is very important is a case called We the Patriots versus Connecticut. And what the Connecticut legislature decided to do is to remove the religious exemption from the vaccine mandate that applied to school children and college students. This is a very important case. It's dealing with the free exercise of religion, the ability for people of faith not to be squelched and discriminated against when it comes to their education. And one thing that makes it so important when we're watching is whether the court is going to reverse case law from the Employment Division versus Smith case, where Justice Scalia, who was, by the way, one of the greatest justices on the Supreme Court, but he really blew it on this one, where he basically took the old case law requiring strict scrutiny and protection for religious freedom, and instead he said, hey, so long as the law is neutral on its face and applies to everyone, it's okay if it impacts religious freedom. There's a few exceptions to that rule. So it looks like there's a good chance they may look at that and go back to old case law, which is much more respectful and providing much greater protection for religious freedom. I think that's probably one of the most important cases right now that we're looking at. And it's pending right now before the Supreme Court. They grant a petition for cert.
They have already granted cert?
Yes.
Great. Okay. Matt?
Well, I think if you look at the history, you go back to the 1990s and you look at free speech. And it was the Operation Rescue kinds of things, the picketing around abortion clinics, and the pro-life movement used the civil rights First Amendment case law to ultimately, eventually win on those kinds of issues. Religious free exercise was gutted, as Brad says, in 1990. And so before that, you could use the free exercise laws as it historically had been, and then Smith just took a completely different direction and weakened the free exercise clause. And so there was a shift from free exercise to free speech that is either speech or an expression of your religion. And those began to take hold, and you began to have one brick built after another until you now have the current Supreme Court that is now, I think, very strong on free speech and much, much stronger on free exercise of religion. And I think it's just a matter of time. It's not if, but it's just a matter of time when they overrule the Smith decision. I think that's coming, and that could be any term now. But I think what we see now is a pendulum swing, and that's in part due to the composition of the justices, particularly the current justices that are there. You saw this particular shift with the addition of Amy Coney Barrett with regards to the lockdown cases regarding churches and places of worship. Up until the time that she was confirmed in the fall of 2020, it was a 5-4 decision on those in terms of these emergency injunctions pending appeal. And then when she took office and was seated after Justice Ginsburg passed, it flipped 5-4 the other way. And we even got a 6-3 decision in one of our cases on the mandate. So those kinds of free exercise cases, the kinds of cases with regards to the expressive activity with respect to the LGBTQ, I think that particular issue, the collision between LGBTQ issues as it relates to free speech and free exercise of religion, is the big area that the Supreme Court will need to address. So far, it looks good in the direction that we have just recently seen it go, but there's a long way to go as well.
Jeremy.
Yeah, look, I think it's appropriate for us to step back and look at where we've been and where we're going, right? The last couple of years of the Supreme Court have been phenomenal, but remember, there was a case that was decided the year after I was born, Lumber versus Kurtzman, the year before I was born. I don't want to age myself too much here. But that case has been horrible for religious free exercise and around the entire country. But a couple of years ago, because a football coach decided to take a knee and stand up for all of your religious freedom, Coach Kennedy's case, Justice Gorsuch says that now religious speech is doubly protected under the Constitution. That's a massive, seismic shift in the law that has occurred in the last couple of years. We can point to everyone on the stage of a case that they've had at the Supreme Court or elsewhere that has contributed to get to that point and is now building upon that as well. So I think if we stop and just simply say, praise the Lord that we've gone from an overly restrictive pattern of behavior of the Supreme Court of the United States to where we are right now in verdant fields of being able to protect religious freedom, religious free exercise, religious speech, that's phenomenal. One thing I think we put on the radar for what's coming up, and it's in the very near future here, as in Monday of next week, the Supreme Court is going to be hearing arguments on the net choice cases. Now, that doesn't seem like an immediate thing for religious free exercise or something like that. But I would guess if I ask you to put your hands up, most of you in this room have had an issue with social media at some point in your careers, whether that's your personal Facebook page, your YouTube channel, whatever it might be, you've had an issue with social media censoring things. Well, this is the case that's going to be talking about two bills, one out of Florida, one out of Texas, that are going to drive that very issue. We filed a brief on behalf of the Babylon Bee, and they had famously a huge issue, right, with Twitter, now X. It requires somebody spending like $40 billion to correct their own problem. They had to go out and Twitter said, look, if you're going to continue to have this position, holding out Rachel Levine as Man of the Year was the post that they put out on Twitter. If you will not take that down, we're going to keep you off of Twitter. And Seth Dillon, to his credit, said, no way. We're not apologizing and playing your game. You can keep us off of Twitter. That's just fine. And thankfully, Elon Musk ponied up $44 billion, and one of the first acts that he did as a new owner of Twitter was to put Babylon Bee back in place. But the point is, whether it's Seth Dillon, Babylon Bee, not the Bee, sometimes hard to distinguish between real headlines and not the Bee headlines, or if it's John Piper or Franklin Graham, all of them have suffered some level of censorship by big tech media companies. I'm grateful for lawmakers that are willing to say, let's put an even playing field out on the path for everybody to play on. Enough of this censorship by social media.
Thank you. Ryan.
Well, much like the Kansas City Chiefs, Rachel Levine is a two-time champion winner of Man of the Year, recently renominated. The beauty of going last is you get to hear all of these good perspectives, and I agree with all of them. One thing I want to tack on what Matt said, the U.S. Supreme Court is going to have to address the intersection of free speech and the ability of believers and people of Orthodox faith to speak truth concerning human sexuality. And we had a case pending, a cert petition pending in Brian Tingley's case. He's a counselor out of the state of Washington who was told by the state, you cannot engage in talk therapy if you're going to counsel minors to live consistent with their biological sex. And that was deemed illegal, an illegal practice of medicine by the state of Washington. We went to the U.S. Supreme Court with a cert petition. That was denied. Interestingly, the 11th Circuit out of Florida went the opposite direction on that case. So the court will have to address that tension.
Great. In the Murtha versus Missouri case that Ryan was just talking about last week or so, I filed a brief on behalf of NRB as amicus in the case. And we argued that the correct amount of coercion that the government can place on social media is zero. They cannot even suggest that it's an illegitimate government activity. I'll start with you, and I've asked each of you to briefly, 2-3 minutes in light of our time, to tell us about some of the cases that your organization is litigating right now.
It's going to be a lightning round. So we have a lot going on right now. I want to focus on just two key areas. One is bouncing off what we just talked about, global censorship of ideas, the concentration of government and private power coming together to cancel voices that government and private power disagree with. We have a client right here in the state of Tennessee, Indigenous Advanced Ministries, that was debanked by Bank of America, told that their bank account was being canceled. Why? Because this was not, quote, one of the types of clients that Bank of America wants to deal with anymore. What is Indigenous Advanced Ministries? It's a ministry that provides aid to orphans in Uganda. How can that possibly be the type of client that Bank of America doesn't want to do business with? So we are next week going to be testifying here at the Tennessee legislature in support of a piece of legislation that prevents banking institutions from debanking their clients based on their ideological viewpoints. That's one thing we're working on right now. Second, we have two cases pending at the U.S. Supreme Court right now. They're going to be argued within the next month. Both are cases that are pushing back against overreach by the federal administrative state, both in the space of life. The first one, Alliance for Hippocratic Medicine, is a case where we're challenging the FDA's approval of the mifepristone drug, in particular, their removal of protections for women who receive this drug. The FDA, recognizing the drug was so dangerous, required women to receive that drug from a physician, to have an in-person visit. That was removed by the Biden administration. Now they can receive this drug by mail after a telehealth appointment. And they're suffering terrible consequences because of that. We're asking the U.S. Supreme Court to reimpose those key protections for women so that their health is not jeopardized. The second case, the Intala case out of Idaho. We have the privilege of representing the state of Idaho as co-counsel with the Attorney General there in Cooper and Kirk. We're asking the Supreme Court to say that the Health and Human Services Department's interpretation of the Intala statute, the anti-patient dumping statute that tells emergency rooms you can't dump patients who are uninsured, they said that statute requires emergency room doctors to provide abortions.
Chairman.
Well, I ended the year, and this may get me kicked off the stage, I'm not entirely sure, but I ended the year being co-counsel of the ACLU, and I've started the year being possibly quoted by the Huffington Post. So the Lord may be returning very soon. These are, so the ACLU issue is a very interesting one because it happens to be, we represent with the ACLU, and this is again just very interesting, wall builders, David Barton, Tim Barton, those guys. They decided to put an advertisement, they want to put an advertisement out on the DC Metro buses that go around town. Their advertisement pictured George Washington in his posture of prayer outside of Valley Forge, you know what I'm talking about. Had the word Christian question mark on it, and said to find out more about the faith of the founders, go to wallbuilders.com. The Metro rejected the ad. There's another ad very similar to that with the acceptance of the Constitution and the Constitutional Convention, rejected that ad as well. And so we filed that case because there is a pending case where there's a split in the circuits amongst this. The DC Circuit years ago rejected this whole thing, but it was when Judge Kavanaugh became Justice Kavanaugh, the issue was opened up in the Supreme Court. We're trying to figure that out. So we're working that issue back up through the courts, whether or not you can have religious speech on the side of a bus inside of Washington, D.C. As all the good things that we've accomplished over the years in terms of free exercise and speech, it still requires us also working at the lower levels as well. We filed cases in the last 2 weeks, one in New Hampshire and one in Hawaii, on almost the exact same issue. One happens to be a barn in New Hampshire, the other one is a home on the island of the Big Island in Hawaii. One is a church and one is a synagogue. The commonality, they're both using their homes for religious worship, and the towns or the counties are punishing them for daring to use their own private homes for religious free exercise. In 2024 America, that makes zero sense to me whatsoever, but here we are working on these things.
Well, Jeremy, we had the ACLU National and Massachusetts actually filed an amicus brief in our case, Shirley versus City of Boston. And so we used to see more of that back in the 90s. And then they got overtaken by the LGBTQ agenda, and now it seems like they may have some sympathy to actual free speech cases. So we won the case 9-0. But following up on what Ryan was saying earlier, before I talk about some of our cases, in terms of where we have come from, if you look at what happened in 2022 and 2023, and this should be encouraging to everybody, there are 4 significant cases from the liberal 1970 Supreme Court that have been overturned in those 2 terms. Lemon versus Kurtzman, 1971. Roe versus Wade, 1973. You have 1977 with the Transworld Airlines case with respect to weakening the Title VII protections for people of faith in the workplace. And then you also have the case that involves the affirmative action for admissions at colleges and universities. All four of those cases were overturned, and so you see this liberalism of the 1970s now being readjusted in just 2 terms, and that is a significant shift. We think often about what happened and the consequences of overturning Roe versus Wade. But what Jeremy said is there is another significant shift. And I know what First Liberty is doing, what we're doing at Liberty Council as well, is utilizing that shift between the Shurtleff case and the Coach Kennedy case. Those 2 cases come together and overturn that 51-year-old precedent. The problem, however, is, although it's a significant change and it frees up the proper interpretation of the First Amendment Establishment Clause, which was not only used to distort the Establishment of Religion Clause, but also the Free Speech Clause and the Free Exercise Clause, that has to be implemented now, and there's a lot of people, school board attorneys and others, that still think it's the old 1971 version as opposed to the 2022, post-2022 cases that we are working on now.
Yeah, we at Pacific Justice Institute actually now have more offices on the East Coast than we do on the West Coast. That said, I'd like to focus on 2 cases on the West Coast in particular. One is dealing with the LGBTQ issue involving businesses having to compromise their convictions. And it's a great case we have. It's called the Lipa Spa versus the Washington Human Rights Commission. It's an important case involving a Christian-owned Korean spa. Now, if you know it, it's for women, all right? So if you know anything about Korean spas, you don't go there if you're modest, all right? That's the way they are. As it turns out, a man comes in, walks in, and you pretty much know what I'm about to say. He says, hey, I want to go to the spa. I see myself as a woman. Now, even assuming for the sake of argument that he's sincere and has genuine gender dysphoria, these owners of this Korean spa are saying, hey, wait a minute, no, we can't allow that. There are women and their teenage daughters in there right now. We can't let you go in there, take off your clothes and look at them naked. I mean, we cannot allow that. We won't allow it. He leaves, reports him to the Washington Human Rights Commission. So this is like George Orwell in 1984 here, where they sort of mean the opposite of what they say. Because this commission files a lawsuit to destroy this Christian-owned Korean spa with righteous, reasonable, rational policies regarding modesty and privacy. So they were attacked. We now have this case. We're representing them before the Ninth Circuit. And of course, we have lots of cases dealing with pronouns, school teachers being told they have to lie to parents. These are bubbling issues that will make their way to the Supreme Court, I know, in the future. Another real important religious freedom case I'd like to touch on is dealing on the other end of the Pacific Coast, and that's Foothills Church versus the California Department of Social Services. In a nutshell, they went into this private, church-run Christian preschool. They shut it down. They violated all kinds of constitutional rights. But the most important one, as I see it, is when they're saying you cannot compel these preschoolers to have to listen to Christian music, sing Christian songs, or listen to Bible stories. No joke. So this is allegedly a violation of the California Daycare Act. And so we are challenging this. It's a very important case on the extent to which government can come in and dictate what any religious institution, in this case a private Christian school, can say or not say. It's very important in the long run for religious freedom.
Wow. Let me just say a couple of things. As many of you may know, I was, until about a year and a half ago, the CEO of the Alliance Defending Freedom, and worked hand in hand with all these organizations. And 2 things I'd like to say to all of you all. One is, please put these organizations on the air as often as possible. Your people need to know these stories. They need to support these organizations. But they need to have the understanding that if they are in trouble, or their friends are in trouble, or their church is in trouble, there are people who are going to help them. the left knows that the ACLU is going to help them, and our people on the right often don't know that there are organizations that are out here to help. These are all great organizations. Please get them on the air, and please help them. The other thing I would say is all these organizations are growing, they're doing well, but combined, they're about, the best I know, the budgets here, they're about 40% of the size of the ACLU's national budget. And so Christians need to decide if we believe in freedom as much as the left believes in repression. So I just urge you to help get that message out. We need to grow, all these groups need to grow, and we need to be able to defend freedom more robustly. So, last question, unless you guys have been pretty good about making the time. That's amazing.
For lawyers.
For lawyers, yeah. And some of you preach a little too, and so, wow. The last question I have planned is, there are dark moments that we all have to face, and there are cases we don't like. We didn't like it when Baron L. Stutzman's case was rejected by the Supreme Court, but then 303 Creative came along and righted that ship in most respects. But do you generally have hope, or do you have despair?
First, I would like to thank all of your stations out there who carry the Dacus Report. You are literally the lifeline to our brothers and sisters in Christ, where we're able to defend them because you carry that kind of information and other information too as well. That plays a key role in our ability to represent people. And I know it very well because as we've seen it expand on radio networks, our cases are increasing and exploding across the country because of that, as with the other organizations as well. So I just want to let you guys know you play a very important role in our ability to be able to connect and to serve and take on these cases without charge. We have over 200 ourselves. I know they have lots and lots of cases themselves. And that's because of you, point one. Point two, we can't ignore the challenges that we're facing today. I agree with everything that was shared so far. And in addition, we have a lot of tyranny in our courts. We've seen it out of New York, Washington, D.C., Atlanta, Florida. I'm just sort of thinking hypothetically, or no. Unfortunately, not hypothetically. So we see a lot of judicial tyranny, particularly at a state level. And that's concerning, because that tyranny can be applied to any of us if these state court judges get their way. Now, my optimism point I'd like to end on is the fact that the former president appointed 3 justices of the Supreme Court, and as already been mentioned, has shifted the court to be the most freedom-loving court in terms of free speech, free exercise, sanctity of human life, individual liberty, even parents' rights in terms of school choice, than we've ever seen in our history, in my history. So we've got a great Supreme Court, and the key is for us to use this court, for us to take these cases on, which we're all doing, before the Supreme Court. We see the tyranny at the lower court level, and to fight it aggressively, because we've got the best Supreme Court in my lifetime, and any of our lifetimes, I believe, that are here today. So it's not the time to be discouraged, and also it's the time to be faithful with what God's given us. Just as Matt said, the rapture hasn't happened. It's not the time for us to live like the rapture's happened and we were left behind. Instead, God wants us to boldly go forward. He's with us to the end. What's the worst that can happen? You get shot and executed. Okay, we all have to die someday, right? So even in the worst case scenario, there's no excuse not to be faithful with what God has given us for this day and this hour.
Thank you.